All right, guys, this is Raymond De Leon with SmoothOperationofLaw, and today we're going to talk about the preliminary parts of a cease and desist. Now, before we get into that, I want to take a second to say thank you guys for yesterday. Yesterday, you guys were awesome. I saw some of the comments in the videos, okay? And if you look in the comment section of yesterday's video, which was the second part of why the SPC process doesn't work and never will, you will see that there are people corroborating this process. That's very important because that means that they have experience. So I appreciate you guys for corroborating it. Okay, sometimes we don't need all of the views on earth, and sometimes we'll make a video that's not for everybody. Oh well. I like making videos that will help people try to understand and realize their true potential and power, okay? And I just need to address one thing. The one thing is that I know sometimes it could seem like I am a little bit upset during the videos, but from me to you, I'm just really pouring out my heart and my passion because I would rather you guys not open yourselves up for certain type of misinformation, which misinformation in its true definition is that they're telling you some truths, but the end result and the conclusion is false. And that's what I'm trying to prevent. The reason why I'm trying to prevent that in my reporting and my First Amendment expression, because this is just an editorial in the form of a vlog, is because, hey, check this out. You know, you guys are trying to really learn the way, and there is a real way to skin the cat. But a lot of times they have a lot of truth in what they say, but they're missing the final point that makes it effective. And dogma and opinion are not for law. And even though we have politics involved and sometimes the decisions that are made by courts, they're inappropriate. And we need to go ahead and, sharpen our likelihood of success. So I appreciate you guys. Okay, and I'm glad I did that video. It really took a lot off my chest. Anybody that saw the video, I hope that you found out to realize that sometimes taking certain actions with the SPC process and everything like that, it could lead you to a liability because the guys with the guns will enforce what is their operative. And that's very important. And even if nothing ever happens, why open yourself up to failure? Why open yourself up to being able to be, imprisoned or anything like that simply because somebody can take the little bit of information that you gave and weaponize it against you just because they think you're dissidents? Federal prosecutors do it all the time. State prosecutors do it all the time. Okay, they're not the most clean-handed people, not always. Okay, and sometimes they are clean-handed. You're guilty. But none of us are corporations. But we need to start thinking more corporative in order to get cooperation from the operation of law in this country. And so understanding your enemy is to understand yourself. And to understand yourself is to increase your likelihood of success. If it was up to me, I would eliminate and eviscerate all people who do not know what the hell they're talking about that offer it to you for certain financial sums in order to monetize you and your disparity to no avail. Okay? And you don't get the remedy. At least everything that I say can be found on the internet. So there's no argument. And I never see really people arguing any of the videos. But with that being said, let's get into this. All right. So when you write a cease and desist, okay, you're supposed to, as I said, in binding of a non-signatory, add an arbitration clause. This is a mock arbitration clause. So here it goes. In the event of any dispute, claim, or controversy between or among the parties to this agreement arising out of or relating to this agreement or any breach thereof, including without limitation, any claim that this agreement or any of its parts is invalid, illegal or otherwise voidable or void, whether such dispute, claim, or controversy sounds in contract, tort, equity, or otherwise, and whether such dispute, claim, or controversy relates to the meaning, interpretation, effect, validity, performance, or enforcement of the agreement, such dispute, claim, or controversy shall be settled by and through any arbitration proceeding to be administered by, and then you have your choice of venue. American Arbitration Association, or any like organization successor thereto, and then you're going to put city-state, in accordance with the American Arbitration Association's commercial arbitration rules. So now you have the rule control. Each of the parties to this agreement hereby agrees and consents to such venue and waives any objection thereto. You bound their ability to object in a contract. The arbitrability of any such dispute, claim, or controversy shall likewise be determined in such arbitration. Such arbitration proceedings shall be conducted in as expedited a manner as permitted by the commercial arbitration rules, formal or informal, of the American Arbitration Association. Both the foregoing agreement of the parties to this agreement to arbitrate any and such disputes, claims, and controversies as a result, determinations, findings, judgments, and or awards rendered through any such arbitration shall be final and binding on the parties. Hereto and may be specifically enforced by legal proceedings. Notwithstanding any provision of this agreement to which state laws govern this agreement, all issues relating to arbitrability or the enforcement of the agreement to arbitrate contained herein shall be governed by the Federal Arbitration Act 9 U.S.C. Section 1, or subsection 1, and whatever, and the sequential, and whatever is, following that. All right, and the Federal Common Law of Arbitration. So now, that arbitration clause is a complete type of arbitration clause, but it is not as complete as Smooth Operation of Law does it. Because I like to add NDA. I like to add, no oral argument based on the filings only type of proceedings, which means nobody shows up. And there's other options that I like to put into the arbitration agreement, which make it so much more suffocating. And it allows for parties not to add to the proceedings any other garbage, because I'm going to be able to, with the cease and desist, prove that after the date of the cease and desist has given them time and opportunity to cure, if they have not performed the terms and conditions of the entire agreement or portions thereof, they will be held to a breach of contract arbitration proceeding. Now, I know that sounds like a mouthful. That's why all my videos isn't for everybody. Okay, it takes a certain type of mind to be able to even understand what these videos are. You're not alone if you look at my videos and say, I don't know what the hell he's talking about, and it's way above my head. If it's way above your head, then why don't you reverse engineer some of the topics and get smarter? If you don't have the time, then you're not really serious, and then go away. Okay, go away. But if you're actually trying to learn, then reverse engineer the concepts. And if not, come get some OJT. Hit me up. Links are in the descriptions. You can contact me. And if you feel that you need to have a consultation, we'll do it. Okay? But we'll have a consultation. You become a trustee of the trust. Okay? And I'll allow you to get some OJT. Now, outside of that, if you have no idea what's going on ever in my videos, well, share it with somebody who maybe might know. You know what I mean? And if you don't want to share it because you just hate the attitude that I have, well, it's probably because you have absolutely no fucking idea. And that's okay. That's okay. You can be mad. But here's the deal. Now, cease and desists are how you prove willful infringement. Yesterday, I talked in the video about $2 million that you could get pursuant to Title 15 United States Code 1117. There's your law. You can scroll down and find it in Section C. And you will see that in Section C, you can get $2 million for proving willful infringement, up to that, right? So what I'm saying to you is that if I had to get my way and it was worth $2 million, would I not want to learn this? It's almost like if you're an SPC, why would you not want to get the maximum amount of damage against the opponent? Okay, so let's talk about the cease and the use. Upon termination of this agreement, due to a breach it's supposed to say specific terms of use or required performance expressed herein, trustee as prosecutor, because yes, you are going to prosecute the civil suit. So that's okay to say. Now, trustee as prosecutor will immediately require that its licensee immediately cease all use of the products, cease all display, advertising, and use of all trademarks, trade names, and logos belonging to your, and then you're going to belonging to and put, your trust name. and will not thereafter advertise or display any name, mark, or logo which is similar to any such trademark, trade name, or logo. Upon such termination, the infringer, so upon such termination, let's say XYZ, whoever, shall require that its license, shall immediately cease to use, its licensee. So if you have a subcontractor, I'm supposed to change that. Sorry. This is a template. So I would read it and change it normally, okay? But at least I'm making an oral note on this reporting. So it would go, Jesus, I lost my fucking spot. Okay, that its licensee shall immediately, 1, cease to use any marketing or other materials that identify it as a representative of blah, 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 or the products and services, and remove all signs, cancel all business listings, and take such other reasonable action as may be necessary to remove its identification as such an agent or representative. Infringer shall properly disclose to the trust the identity of and the current state of negotiations with all and potential subcontractors and beneficial users, together with copies of all correspondence that such potential subcontractors and beneficial users and beneficial users. The infringer also shall cooperate with the trust in effecting an orderly transition of all the activities under such to the trademark or to any successor of infringer, designating by trademark as the case may be. Your trust, right, shall reimburse, you'll reimburse them for any reasonable costs incurred by its in effecting such transfer. And that portion right there is going to be a reimbursement of, we will not take you to fucking, court for a willful infringement. You can offer in that portion a covenant not to sue, and that is considered payment. Because if they breached you, then they need to return it and take care of all damages. So that last wording, I left it like that just so that I can address it orally. A covenant not to sue is pretty much an agreement that you will not take any action, but they have to fix their mess. And that includes everything that they've messed up. And it should be of no cost to you for the breach of that agreement. You should be indemnified. But that's why these are only portions of a cease and desist with some language. Now, do I have, obviously, an agreement where a cease and desist looks like a license agreement in which these things are affected with representations and warranties? Of course I do. Am I going to put it up on screen? Hell to the motherfucking no. And the reason why I won't put it up on screen is because why should I just work like that? It's crazy. It's crazy. It's crazy. But everything I'm saying is true. And if you want to reverse engineer it, you can. Take the time. Because sometimes when you find things for yourself based on promptings, you will better be able to understand the information because you actually put in some labor. And a lot of people, they want to know, but they don't want to labor. Well, if you don't want to labor or you don't want to really know, then you are your own worst enemy. And I like that. I like it when people learn the hard way and learn in the end than if they never learned at all. At least 100% of the people that search this information understand that there is something going on. I applaud you for that. You also understand that whatever's going on, you're being subject and victimized by it. Whether it's child support, whether it's mortgages, whether it's anything, right? Because you can't go to court again and argue the vapor money theory. You can't say that they didn't loan you any money. You're not going to get away with it. There's court protocol for it. I've showed it in previous videos. And so the real thing is to not become a secured party creditor, but to become a secured creditor. That's how if you learn how to operate like a secured creditor, you're going to have a higher sense, even if your case is criminal. Like if I have a criminal case, it could still be true that the irrevocable trust can sue the judge. I've been saying it for the past couple of days. Okay, but you got to get into contract building. You got to learn those things. You have to learn trust law. You have to learn how to apply and enforce your trust interests. You have to learn intellectual property rights. You have to learn arbitration. You have to learn admiralty. You have to learn commercial law. You have to learn XYZ, tort law. You have to learn civil rights law. There's a big old thing. And here's the other thing too. Yesterday I had mentioned that a lot of these so-called gurus, they get so angry when you start posting this stuff because they're talking about, all these bonds and things like that. Okay, this process, think about it. If a bond is commercial, this process would inherently address that and the bonds. And a lot of people are like, oh, you're going to get killed if you talk about that. You're not going to get killed, not if you're going to court. Oh, well, people can die even if they're right and go to court. Okay, but then that's criminality, right? Okay, we're not going to underestimate the system's ability to conduct criminality. Oh, no, we're not going to. Okay? But what we're going to say is that most generally it ain't going to happen. It ain't going to happen. Okay? I know for a fact. That's my personal opinion on what from experience. So what I'm basically saying is that if you use the law and you do it right, you can start to affect a lot of the secured party creditor processes by understanding how to operate as a secured creditor. Don't get mixed up, okay? This right here is only portions of the agreement, but there are two highlighted portions that I want to give to people so that they have an understanding on where to go. Now, let me give you an example of something else. Hold on, because I'm about to pull it up. Let me see if I can pull it up. If I can't pull it up, then I won't pull it up. No, you know what? I'll save that for tomorrow. But here's the deal. Here's the bottom line. Okay? Trademark infringement leads to a waiver of sovereign immunity. And it leads to the attack of the transactions on the parties. You could have, pretty much, family court trying to say that you got to pay for a baby that ain't yours. Okay. You go ahead and you stop them from using your name. Because if they do use your name in their office, they waive sovereign immunity. Now, is that really defrauding the government? It's not. Not if the laws are there. Not if the laws are there. Not if it's coming from an irrevocable trust. It's not. That is a fact. I have the Supreme Court cases for that type of stuff, but I'm not going to go and search all of them right now. Okay? You don't have to take anything in this opinion op-ed as fact. But I'm just saying, okay, from somebody that tries to give an opinion based on facts, I know it to be true for a fact and have researched the Supreme Court cases that state that there's a waiver of sovereign immunity, right? Allen v. Cooper, and there are other, you can't be held liable for exercising a civil rights claim. You can't be held liable for exercising a property rights claim, especially if you can prove your position as the property owner, period. And so I'd like to thank you guys for yesterday's video. You guys did awesome. Now you guys know, pretty much how a cease and desist can be proportioned, okay? Things and terms that you can put in an agreement. And I also want to address one more thing. I'm getting a lot of views. Can you guys hit that like button if you like it? Come on, let's do that. Let's hit that like button if you like this. If you don't like it, then leave it alone. But it only takes you 2 seconds to hit that like button. And if you're watching the videos and you're not subscribed, come on and subscribe and hit that notification bell so that you can get the videos, okay, whenever I post them. If you guys have any questions or concerns, stop being afraid. I'm not going to make too many more of these videos. I'm just letting you guys know that. Not because of anything, but because I try to only hit these topics on a general note. And the reason why I try to only hit these topics with a general note is because anything else would be me just, showing people how to do the process. I'm not going to do that. I'm going to give you the laws because that's safe. That's safe. But hit me up, PM me, okay, if you got some situation or whatever like that, and just ask some questions and we'll see what's up. Okay? And if you're just calling because you're just crazy, don't call if you're crazy. If you have some sort of predisposition into some of these occult groups and stuff like that, Okay, I mean, a lot of people get mad when I say I'm not a Moor, I'm not, you know, one of these SPC groups. They get real upset. They're like, well, what is he doing? It's not part of my ability to. What I'm doing is I'm taking the SPC process and showing you how to do it for real. That's what I'm doing. I'm showing you the SPC process, but how it's supposed to be really done so that you can get debts discharged for real. This isn't a scheme. That's why I show the law. Do you see what I'm saying? It's not just some other guy blabbing for an hour. But thank you. And if you really have any type of understanding, you'll hit me up. Because you'll at least, that's how I know when people are actually, they actually have experience. Because usually, like, you know, if you took a flying saucer and you dropped it in the 1600s, they wouldn't know what to do with it. That is literally how I know that you know a little something. Because usually those that actually message me on Facebook or whatnot, subscribe to the channel and leave a comment, those guys actually know something. So I applaud you guys. But a lot of the guys that just stay quiet and silent and just like, I don't know, I don't know. I know you can't address it. And even if you don't know, it's okay to come and get some OJT. You might get your eyes opened the right way. Instead of learning some process that could either A, get you in trouble, or B, be incomplete, or C, you know, put you in a position where you're not getting what you want, the remedies that you need. Okay? So God bless you, okay? And have a good day.